The California Invasion of Privacy Act is having a moment, not necessarily in a good way. We're lucky today to have Stacey Bovin with us to help us better understand this new flavor of class action litigation. Stacey is based in Nixon Peabody's San Francisco office. She's a member of the firm's cybersecurity and privacy practice, and she also leads Nixon Peabody's California CIPA litigation team. So, Stacey, welcome to A Little Privacy, Please, first. And maybe we can just start with having you explain what CIPA is, and more importantly, what's up with this flood of CIPA litigation in California right now?
We are seeing a veritable flood of litigation in California under the California Invasion of Privacy Act, or CIPA. And CIPA is a bigger statute, but I want to talk specifically about the wiretapping statute, because what we're seeing in California right now is all of these companies that have public websites who did their data due diligence. They dotted the I's, they crossed the T's with their privacy policies and their terms of service, are suddenly getting hit with these lawsuits claiming that they're liable for aiding wiretapping. Now, what do you think about when you hear wiretapping? What I think about is a guy in an unmarked white van with big headphones on trying to listen to a conversation across the street. That's not what's happening with a website. So it's a bit of a strange surprise for these companies who don't understand suddenly why they're on the wrong end of a CIPA lawsuit. And if this sounds confusing, it's because it is, but let me back up and sort of explain what CIPA is. It's a very old statute that was put on the books to protect Californians against wiretapping. Back when, telephones were connected with wires, it prohibited tapping a phone wire or trying to learn the contents of a message that's sent over wire, or for assisting someone in those illegal eavesdropping activities. We're now seeing plaintiffs try this new creative application of CIPA to claim that the use of third-party technology on a website is actually violating the California Invasion of Privacy Act.
So why is this happening now? It feels like very all of a sudden.
People have never been more concerned about data privacy. Some of this has to do with what we're seeing in the headlines. There's a lot of talk about generative AI with ChatGPT and Gemini, but also people are starting to notice signs that they have data, right? They're seeing these targeted ads that show they have data and they're wondering who has access to it. So data privacy is very much part of the zeitgeist at a time when data has never moved more quickly. And this also happened to set the stage perfectly for this kind of litigation. And then the Ninth Circuit cracked open the door with an unpublished decision that was meant to talk about a very specific, narrow issue on consent under CIPA. But it did have language in there saying that the wiretapping section of CIPA applies to internet communications, thereby opening up the door for this kind of litigation. And I want to back up and explain exactly what plaintiffs are claiming here. So what's happening with California companies who are getting sued for wiretapping for activities on their website, the argument goes a little bit something like this. The website user who goes to a website and say they fill out information in a form, or they communicate with a chatbot, or maybe they just click around the site. They're claiming that that activity is a communication. And because almost every website uses third-party software to improve the functionality on their website, whether it's adding in a chat feature, or maybe they're using third-party software to manage their data through Session Replay or Metapixel. The use of this third-party software is what plaintiffs are pointing to as eavesdropping. They're saying the third-party software is the eavesdropper, and they're eavesdropping on the website user's communication through the site. And then they're turning around and suing the website who paid for the software, saying, well, you're aiding in eavesdropping, and that violates CIPA.
So, Stacey, who really is at risk of getting caught in the CIPA litigation web, and what is that risk?
Yeah, that's the important question, Jason, and it's a scary answer. Because the use of third-party software in websites is so ubiquitous, it basically puts any company that's doing business in California with a public-facing website at risk of CIPA litigation. And in terms of what the risk is, it's expensive litigation. CIPA carries a statutory penalty of $5,000 per occurrence. So say you have minimal traffic on your website. Maybe 5 people go to it a day, and you get hit with a class action litigation for, on behalf of every user who's been to your website in the last year, you're looking at damages claims in the millions.
So Stacey, I think a lot of our listeners are going to want to know, what can they do? How do they protect themselves and their company?
Yeah, this is the important part. Companies have got to get their data house in order. I know that everyone has heard this a lot. We say it to our clients early and often, but you have to make sure that your privacy policies, your cookie consent banners, your terms of service, that all of those are current, they need to be accurate, and they need to not just comply with California and federal law, but they need to be formatted in a manner that's going to protect your company against this new CIPA litigation. What does that mean? Well, take, for example, websites in Europe. Almost uniformly, if you go to a European website, before you can actually interact with that website, you're going to see a grayed out screen and a cookie consent policy that the user has to interact with. They have to affirmatively select yes or no on cookies and get data usage notifications. That doesn't happen as much in the US, but you're certainly more protected the more communication there is with a website user. There's a big difference between a banner that requires affirmative consent from a user as opposed to a tiny link in the bottom of your website that maybe no one sees. And there are a lot of particularities. Jenny, I know you and I could talk about this all day. But if we zoom out, what's really important here is transparency. There is a consent component to CIPA. So a person cannot consent to eavesdropping or wiretapping and then turn around and sue a website to say, well, you eavesdropped and wiretapped, you assisted in that behavior and it's not okay. And the foundation of consent is transparency. So making sure that you have transparent communication with your website users about the data you're collecting and how you're using that data, that is critical. And in order to have transparent communication, you really need to understand what you're doing with your data. That sounds simple, but it's really not. Technology is developing so fast these days. There's all these new and interesting tools that we can use to work with data. You really have to understand what you're doing with data, how you're collecting it, where it's going, what safeguards you're putting in place for when it's stored, who can access it, both internally and externally, and whether and how you're using the data. Once you know those basic facts, then you can have transparent communication and make sure that your disclosures and your privacy policy are accurately communicating that to website users.
So Stacey, we've talked a lot about cookies. I'm just wondering, are you more of a chocolate chip or an oatmeal raisin type of girl?
Strong opinion. I think chocolate oatmeal raisin minus the raisins.
Well, Stacey, that was really informative. I know this is an issue that's keeping me up at night, as well as a lot of our listeners. So thank you so much for joining us. And that will do it for this episode of A Little Privacy, Please.
Well, if we're going to talk about cookies, the bakeries in San Francisco are next level.